Is everybody? I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign. I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign.
I wanna be the greatest. Everybody on the fake shit. I look around and feel like everybody is the fakest. I make this every day and I'm impatient, hoping one day I blow up from the basement. Statement, the top is so vacant. I don't hear shit that I think is amazing. Waiting for my day when I'm playing sold out shows for 1,000 faces. Hey, give me that crown. Get in my way and to be put down. It ain't your place. No.
Welcome, guys. Justice is a Process is live, and we are here with a major update on the Tyrone Tucker case. I've got some information for you guys. We've got some court filings to review. So it's not going to be a long show. We're just going to be going over some of the court filings, which has some interesting information in them, and we're going to be going over what you may have seen in the thumbnail, what you may have seen here at the titling of the show, and that is that Franklin Tyrone Tucker, it appears, has an attorney. And we're going to get into what my sources are telling me down in Key West. I've talked to some people. It may or may not come to fruition. I have a theory on what's going on. Hopefully Tyrone Tucker lets the attorney stay in the case. But we're going to go over it. We're going to go over some more dirty things that are happening in this case with some filings that have happened from the state. We have motions finally that have been unsealed that we can see now that Tyrone Tucker filed. And we're going to get into all of that. And then I'm going to tell you what I think is happening and why I hope Tyrone Tucker lets the public defender's office take over his case, and we'll see what happens here. So first off, big news. Tyrone Tucker, it appears, has an attorney. And as you can see right behind me, this is the page in the, Monroe County Clerk of Court's office. You can see here it now says Franklin Tyrone Tucker. It used to say pro se here, and it now says public defender. Now, I'm intentionally blocking out the number to the public defender's office, but it is there if you guys want to call in, inquire, make your inquiries. But it appears that the public defender's office is now representing him. Now, if you see here, it looks like on the 18th, there was an application for criminal indigent status. So today's what? I'm filming this on the 21st. Well, it's 20th, 21st, I guess you could say. So 2 days ago, it looks like he filed for indigent status, and they appointed him a public defender. Now, I have a source on the ground down there that I've been speaking with, and this individual's been speaking with Ty, and I'm being told that they had a conversation with Ty, and that Ty represented to them that he simply filed for indigent status. In other words, there's a reason why he would do that, and that is because right now, unless he's indigent, he doesn't get certain things. He wouldn't get access to, say, pens, papers, computers, stuff like that. With him being pro se, it would be expected that he would have to provide those items for himself. Now, this might be some maneuvering. It may be something that because he got indigent status, maybe he automatically gets a PD, public defender, that is. But if this is true, now Ty claimed he was not intending to get a public defender, but that he was hoping that because he was informed of this by this individual who saw this themselves, that he said, well, I'm gonna write a letter to the court and let them know I don't want to have a public defender. They're gonna mess up my case. Now, I am of the belief that's not the case, because I think that if he does not get an attorney involved, he is about to run into an absolute railroading like you've never seen before. I believe the state is gearing up to try to have a very quick, very fast trial that's going to be very narrow. I don't believe John Travis Johnson will show up at the next trial. I believe they're going to say, hey, he's unavailable. I believe they're going to force the testimony through that was from the previous case. That will be read to the jury. They're going to read Paula Belmont's testimony. They're going to put on the expert. They're going to put on Monroe, or they're going to attempt to just, put on Detective Malone. They're going to limit the cross-examination on Detective Malone. They're going to they're attempting to get the motion in Lamine in effect to block out any mention of the IA report or IA investigation. They're attempting to block out the motion to suppress, which Tyrone Tucker will not know how to get that in. It can be brought in. It should be brought in, but they're going to get it. They're attempting to get it barred, and we're going to go over that. That's the latest motion. And then they're going to have Roger Ruggett come on the stand, who, remember last time he said he was similar build to Ty Tucker. They're going to show the Cosme video. They're going to show the Keys Electric video, which is going to, say that'll coincide with Detective Malone's testimony. They're put the officers on that that testified before. They're going to keep it very, very narrow, and then Ty will have, again, they've already made it clear they're not allowing Ty to have contact with Todd O'Quinn. Todd O'Quinn may or may not be available to show up. He may or may not show up. Ty's got to get subpoenas out to him. He's got to try to bring him into court, so he may not get there. And again, it's going to be their goal that they're going to try to keep this thing extremely narrow, and Judge Morgan is going to limit as best he can, I believe, Ty's case that he's going to attempt to present, and they're going to get it before the jury. Now, we all know a lot of evidence. We know a lot of things. We know a lot of questions that are in this case. We know there is an abundance of exculpatory evidence that proves Ty Tucker is innocent, but the state is going to do its best to try to keep all of that out. And I'm told in the last case that there was several jurors, there was a couple of jurors who were somehow very dug in on Ty's guilt. And there was, at one point it was 6-6, and then the judge gave his instructions, and then it moved 8-4. And then there was one juror in the room who was just completely for Ty's innocence and was unmovable, which is where they got the 11-1. But there were 3 other jurors that were sticking with that juror, at least for the time being. And it became clear, this one juror made it clear, I'm never going to vote to convict him. And that's why it ultimately they went back to the judge and said, we're immovable. It's never going to, there's nothing we can do. And ultimately it went. So I bring this up, I share this with everyone simply because it's concerning, because again, we see this case differently because we've seen all the other evidence we've seen a lot of the other evidence. We've seen the Todd O'Quinn tapes. We've seen the fact that there is no evidence. We've seen, Penny Phelps come into the evidence room and interject herself into the interrogation of John Travis Johnson. We've seen the tapes of Paula Belmont after the fact at the hospital, but the jury will see none of that. All the jury's going to hear is that this is a story about 3 drug users who made a decision to go try to do a quick hit and run, grab some drugs, and get high. John Travis Johnson, they're never going to see this guy on the stand. They're going to see it. They're going to hear his testimony. They're going to hear what he testified to in the previous case. And then they're going to go, okay, well, isn't it likely that Ty would have done, be involved in this? Well, yeah. And they're going to hear inconclusive. The state's going to make the argument that only Ty Tucker could have known because of the blood on the handle, which we all know that's not true, because Ty was told in his own interrogation that blood was on the handle, from Matt Bonnet, because it was the knife used to kill Matt Bonnet. So, in that they believed Ty's DNA was on that because he was the one, and Ty said it wasn't me. So we all know that Ty was told this information by Penny Phelps, which he communicated to Paula, but they misrepresented it in the first trial. They're going to try to misrepresent it in this trial, and Ty is going to be unable to adequately defend himself when you have. In the concern I have is this: they are not going to follow the rules because Ty, they already know, or at least they're anticipating, unless Ty changes his tactics, that he isn't going to be willing to make a record because Ty, as he's told me, as he's told others, he isn't in this for an appeal, although he should be. And the state knows that you have no claim for ineffective assistance of counsel when you're pro se, because it's made it clear that you're taking the risk of defending yourself, and therefore you can't go back and say I was ineffective because I didn't know the law or I didn't understand what I was doing. You took that on yourself. You chose not to hire an attorney, or in this case, he's choosing to not take his appointed counsel. So they're going to be emboldened, as they've already been, and like never before, that when they get to that trial, they're going to do anything and everything. These guys are going to pull every dirty trick out of the basket at the back of their hands, and we're going to have to be watching very closely. And Judge Morgan, who has demonstrated that he was willing to revoke his bond for no reason. He's willing to join the state in hiding Tato, trying to keep Tato Quinn out of the case. He's willing to, we haven't seen the ruling yet, but I'm anticipating he's going to rule that none of the IA report, no evidence of misconduct can come in. They're going to use that to keep that out of the trial and keep Ty Tucker from going into it. I do believe they're going to attempt to try to keep the motion to suppress that was filed by Seth LeVay on behalf of John Travis Johnson out of the case. And Ty I don't think is going to know how to get it in. They're going to do all these things. They're going to essentially gut the ability for Ty to have a case, or at least a case that he wants to present. And by the time we get to trial in September, Ty is going to have been worn down by spending 4 months in jail in the summer months. And it's going to be rough. So Ty, what we need here is a lawyer to get involved. And it looks like we have one. So it appears for the time being that if you have a way of talking to Ty, if you can get in contact with Ty, please encourage him, if he gets appointed a public defender, to let that public defender take over his case, because they will know how to utilize the motion to suppress to impeach John Travis Johnson. They will know how to keep out the parts of Paula Belmont's testimony that shouldn't come in. They will be able to get it in the pieces that need to come in. They will be able to limit what the state can do as far as what they're doing with the argument they're going to make in regards to the blood on the knife. They're going to be able to keep that out. They're going to be able to get pieces of his statement in. They're going to be able to ensure that the jury understands that there is no evidence to link Ty Tucker to this case. They may even be able to subpoena certain people, like I believe they should be subpoenaing Gabby, the individual that called 911. She needs to be subpoenaed and brought in. William Alexander needs to be brought in. We need to have in Officer Blake needs to be brought in. We need to have these people on subpoena and ready and brought in. Matt Pitcher needs to be brought in to testify. So again, as we are, and that is, I've got it ready. I've pretty much got everything prepared to play the deposition in full on Matt Pitcher. We're going to do that. It's going to probably take, it looks like, about 5 hours to do. So we're going to do that here. I've just had a lot of personal things going on right now that I haven't been able to get it scheduled to sit down for 5 hours and do that. But we're going to do that, and you're going to see why Matt Pitcher's testimony is so important. And you're going to really hear all of the problems in this case. And you're going to hear a little bit in a few minutes when we start getting into the motions that Ty Tucker has filed. You're going to get to hear some of the things that Ty Tucker would be able to raise by introducing Matt Pitcher's testimony. But these are the things that a good defense attorney can do, because why? You put these people on the stand. You have Gabby, who testifies about the car. She saw someone jump out of the house, run out of the house, and get in a sedan. Was it a sedan? Was it a truck? William Alexander says a sedan pulled up, bloody sweatshirt. Where's the bloody sweatshirt? We need to get the, I can't remember the other officer that was on there who can testify to what they didn't do, that they didn't go down and investigate, that they, that he talked to someone, and that there was talks of two men fighting down by the hogfish. They can make sure Todd O'Quinn shows up, and they can question him about what he saw, and he can raise doubt as to who he saw, that he saw John Travis Johnson run out, not Ty Tucker. By the time you get done, these witnesses are able to raise doubt as to who was there, who was what, and whether the state knows anything at all. You can bring in and make sure that there's Officer Malone or Detective Malone is questioned correctly on why the videos were not properly handled, and how they got lost, and why the CVS videos weren't collected properly, and they were lost, and they were collected on the wrong day. All these things can be handled and brought in, and by the time it gets to the jury, a public defender is going to be able to get a major victory on, in their career, because they're going to be able to absolutely tear apart the state's case. So I hope that what we find out here is that the public defender's office takes over this case, that they request a continuance, and that we get at least a continuance maybe into October, so that they can have the time to adequately prepare the case, subpoena witnesses, and get this thing rolling. But we shall see. But our dream is here. Now, what I believe happened here, guys, and this is what I'm scared of, and this is what I'm scared of the outcome to come. But I'll talk about what I think happened. I can't help but believe that we were, I think it was back on the 11th, I had put out a, episode 21, and I made it very clear that I believed that the state of Florida, and it was a very serious accusation, that the state of Florida was attempting to keep Ty Tucker from getting an attorney, from having an attorney to represent him. So I can't help but wonder if this, when he filed for indigency, if this isn't an attempt, because again, what they are trying to do in this case, and I believe Jimmy Morgan was brought in to do this, and I've said this from the beginning, what they are trying to do is get an ironclad verdict in this case that is unreversible on appeal. One of the things that could have possibly been raised by an appellate attorney would have been the idea that they went in, they revoked this man's bond, he ends up getting divorced by his wife, because of his wife's socioeconomic situation, and because she's got, money, that they use that to block him from getting appointed counsel. And then as a result, he shows up and he's forced into a pro se situation this second time around, an issue I was raising and making. So it's my belief that what the state of Florida is doing right now, what they've done, because it was like he files for indigency, and what do? They go ahead and appoint him a public defender, because what they're inviting him to do is to do what I was told he's already told someone he's going to do, which I think is an absolutely devastatingly stupid move. And I believe what they want him to do is fire his attorney. By firing his attorney this time, it will absolutely remove any claims later that he was denied counsel. And that would have been one of the final vestiges of reversing this case that he could have possibly had later on down the road if he finds himself convicted at the end of this thing. If he removes counsel, fires them, and then proceeds forward, he is now fully owning the outcome of this case. And if he fails to make a record for the appellate court, if he fails to make a record for an appeal, then anything that they do that's wrong, that's incorrect, that's against the rules, that's corrupt, it can never be challenged. Because appeals courts are very, very clear on the fact that if you fail to make a record, you cannot raise that issue on appeal, regardless of how wrong or against the law it was. And since he's not an attorney and he's pro se, and if he fires his attorneys, makes the decision to go pro se, he removes ineffective assistance of counsel. One of the things Ty doesn't seem to understand is that if he allows the public defenders, even if this public defender comes in and is a complete incompetent boob, right? And they go in But if his attorney is handling the case and his attorney fails to do something or fails to put up an adequate defense, fails to protect the record, fails to raise an issue, all of those things can be raised later on as ineffective assistance of counsel, in effect, getting him a new trial. What Ty fails to remember is that until he's convicted, things like the Innocence Project and stuff like that will not look at his case. They sometimes will, but most of the time they're not going to. But if he gets convicted, the Innocence Project can come in. They will take on his case for appellate purposes, and then they can try to get the conviction reversed like they did in the Adnan Syed case, and they can go in and potentially even retry the case with the resources of the Innocence Project. And remember, my father was part, and again, we donated proceeds for his death. My dad was part of that. He worked with them. He handled, this was something that intrinsically we've been, I'm familiar with. So for Ty to, I understand that he's brought attention to his case now, but it is imperative for the strategy, for him to see. And if somebody's talking to him, and again, I haven't had a chance to be able to get in contact with him. I have not been able to do that, but he needs to understand that it is absolutely imperative that he has an attorney with him, even if this attorney is the biggest boob and dumbass in the world, because it is that is a potential avenue later on, if they are really, really bad, that he can raise that issue, because his case, even, is going to eventually get attention, because eventually the Innocence Project will take a look at this case. And anyone who starts doing a deep dive in this case, like we have, like I have, like others have, is going to immediately see the problems within this case. And we're immediately going to be able to see this is an innocent man, wrongfully convicted, who deserves to have who will deserve to have the case overturned. But what Mansfield and company are trying to do is they want to eliminate any possibility that it could be overturned, any possibility that there's any appellate issues. And it's not that there won't be, it's that he won't have properly preserved the record. And the last thing that they needed to do to ensure that was correct was they needed to make sure, they needed to get a counsel appointed to him, have him fire counsel, and effectively waive that issue on appeal. So I believe, listen, these guys, this is the most dastardly, dirty people I've ever seen. These guys are, and they're playing chess, and Tyrone Tucker's playing checkers. He's playing checkers because guess what? He doesn't know how to play chess right now because he's not a lawyer. So he's got to get that help, and he's got to get that assistance. Now, with that said, we're going to go through some of these motions. So the first motion I want to go through here is, give me a moment here. And the first motion I want to do is the Travis Johnson motion on Lamine. We're going to, or Limine, I guess I should say. Keep calling it Lamine, but it's Limine. So let's see here. All right, so here it is. So this was filed by the state. So it says state's motion in limine. The state of Florida respectfully requests this honorable court, to order that the motion to suppress pleading filed by Travis Johnson's attorney, Seth LeVay, specifically the arguments, any alleged factual assertions, or comments contained therein, is not to be mentioned or even referenced in the trial of this matter. In support, the state submits 1. During the first trial, the defendant attempted to enter into evidence the actual motion to suppress pleading Travis Johnson's attorney, Seth LeVay, authored and filed back on April 18th, 2020. This motion was never set for an evidentiary hearing nor ruled upon. This pleading was not a sworn motion, i.e., Travis Johnson did not swear to any of the statements or assertions found within the motion. See attached motion to suppress. 2, it was clear from what the defendant was attempting to do that the defendant believes that the pleading authored by Mr. LeVay could be used to impeach Travis Johnson's trial testimony. The presiding judge at the time advised the defendant such was not permitted. Moreover, Travis Johnson indicated at the first trial he was not aware of the motion his attorney had filed. And again, this is another example of just how dirty these guys are, because these attorneys understand basically, and we're going to get it. We're going to go through the transcript and I'll show you what I'm talking about here. But it is certainly known that any document can be used to refresh a witness's memory. If an attorney would have been handling the cross-examination of John Travis Johnson and he would have said he didn't remember, they would have produced that motion to suppress. They would have asked them to review it and said, does that refresh your memory? That would not have been admitted to evidence. It would have simply been provided for purposes of refreshing his memory, to which he would have then said, okay, yes, my attorney did file that. And then it could have gone from there. So it's the audacity that these guys have to raise these issues. And this is what Vinny Politan was talking about, is that they're literally doing what they shouldn't be doing. They have a pro se attorney and they're taking advantage of the lack of knowledge. They're not supposed to do that. They're supposed to make every effort to close the gap of knowledge and make sure that the non-attorney is able to understand what's going on and understand how to do things. And again, also, in addition, Judge Jones never ever said it wasn't permitted. He simply said that it hadn't been properly admitted, and he hadn't been able to show the foundation. He hadn't been able to do the things that you needed to get to properly admit it. And Franklin Tucker didn't understand how to admit it properly, which it is under a hearsay objection or exception. Right, it's a business record, and he could have gotten it in through Seth LeVay, or better yet, he could have gotten it in through the clerk of court where it was filed under, and they could have sworn to it. It could have been admitted, and it would have been admitted for the limited purpose of saying that Seth LeVay filed this motion, that John Travis, on behalf of John Travis Johnson. It's well known. These guys know that anytime a motion is filed by an attorney on behalf of their client, it's the same as if it's been filed by a client. And an attorney, and again, these guys know this, an attorney cannot file a motion he believes to be false. And that's why Seth LeVay, that's another reason why Seth LeVay could have come down and he would have sworn to that fact that, yes, did you have a reason to believe it was true? Yes, what was the basis for that? It was from your discussions. It was based on information provided from your client. Attorney-client privilege doesn't attach to what he filed in the motion. So when they were trying to throw that in at the time, it was attorney-client privilege. Yes, he can't talk about things not contained in the motion, but the information contained in the motion that they filed in court could have come only from one place, and that would have been John Travis Johnson. That would be allowed to be discussed, and John Travis Johnson would be allowed to be confronted with that and say, your attorney filed this motion on your behalf, correct? Yes. And it states in here that Penny Phelps, walked in the interrogation room and fed you this story, and isn't that true that's what you were alleging in this motion, and which could have only come, which your attorney filed or presented to the court on your behalf. And absolutely, it would be support and impeachment as to what John Travis Johnson was testifying to in that, in his testimony. So this, an attorney would know how to get this in, and would know how to ensure that this was that this was something John Travis Johnson would be able to be cross-examined on. So let's move on here. So number 3 says the state seeks this court to issue an order prohibiting the defendant from attempting again to use any information found within the motion to impeach Travis Johnson's trial testimony or to refer to any evidence found within the motion. The defendant is under the belief that the pleading altered by Mr. LeVay can somehow be attributed to statements of Travis Johnson, and or that the pleading having been filed by his attorney, it can be deemed as having been adopted by Travis Johnson. There is nothing in the terms of applicable applicable statutory or legal authority that supports what the defendant was attempting to do in the last trial, precluding any attempt as requested, which is absolutely ridiculous. Everybody knows. I mean, what he said, it appears, and if I was Seth LeVay, I would be extremely upset, because it appears what they're suggesting is that Seth LeVay made up a story in order to file a motion to suppress, thereby violating his requirement of being honest and only presenting things that he knows to be or has a basis of truthful or a basis to believe that what he's presenting to the court is truthful. So if I was Seth LeVay, I would be extremely upset about this. And then, but it just shows you there's no lengths as to which these guys are willing to go. And I want you to see this comes down. Now, I want you to see how this is written. This is what they're claiming, that John Travis Johnson, this somehow should not be attributed to John Travis Johnson. It's in his case, motion to suppress statements. It's termed, comes down the defendant, John Travis Johnson, pursuant to Florida Rule of Criminal Procedure 3.190, by and through the undersigned attorney, and files this motion to suppress in the above style manner. Support of shows the following. He is asserting facts. He was taken into custody by Detective Kevin Pitcher, and that there was a pre-planned ruse. And it goes through here, and all of this information only come from one person, John Travis Johnson. Seth LeVay could not have made this up. He couldn't come up with this, on his own. But that's what they're claiming, that he essentially made up the facts in this motion. Check out 15. John Travis Johnson hereby reserves the right to supplement and amend this motion to suppress, among other things, this defendant was recently declared insolvent for cost, and defense counsel is currently seeking JAC approval for retention. Tantamount to note at the outset, in the instance, John Travis Johnson asked Detective Pitcher if he needed to have an attorney present at this juncture instead of terminating an interview or affording Mr. Johnson the opportunity to speak with an attorney. I mean, look, these things are all the statements made to Detective Pitcher were obtained after Mr. Johnson was deceived into waiving his rights to present. The state may not use statements, whether exculpatory or inculpatory, stemming from custodial. Of course, there are some things that shouldn't be able to come in, but the fact that Mr. Johnson, through his attorney, was claiming that that the motions that the police statement be suppressed, because he was claiming that she invoked or that she used the read technique, thereby getting a false statement out of him. He was thereby claiming that the statements that he made were false. Absolutely, this should be able to come in, and you can see, wherefore the defendant respectfully requests. Now, obviously, this was prepared by Seth LeVay. This was submitted by Seth LeVay on behalf of John Travis Johnson, but it is still considered to be a motion that John Travis Johnson would have held out to believe that the facts in that motion were true. And the facts in that motion are that Penny Phelps made up a story, told Travis Johnson that story, and that Travis Johnson then parroted that story back to him under duress, and due to the use of the read technique, which, of course, I've shown off on this channel. The expert that came in and reviewed John Travis Johnson's testimony and said, without a doubt, that he was coerced, and that his testimony that he gave, or that his statement that he gave, and ultimately his testimony, which was based on that statement, did not meet the standard to show that it was testimony that was truthful, because he did not create any new facts. He simply parroted back facts already known in evidence, already known to investigators, and he presented nothing new. And everything he presented was already known to investigators. And that is a problem, and that is a concern. So the idea here from the state of Florida that, this can't be used as impeachment is ridiculous. Now you're going to see here where, this is the section of the trial, where they're talking about the fact that John Travis Johnson did know about the motion. And again, this is where Franklin Tucker, not having an attorney, blew it, because he could have used that, even if it wasn't admitted at that time. He could have used it to refresh his memory. And he could have said, hey, do you remember filing that motion to suppress? And the jury would have known he filed a motion to suppress. Even if it never made it in, even if Seth LeVay never makes it to the stand, he could have at least refreshed his memory and had him tell the jury, yes, now I do remember filing it. The contents of the motion may have never been able to come in, but it certainly could have been used to refresh his memory. And that was a missed, blown opportunity. All right, now let's move on. That is the first thing, and that is the first dirty. It's not the first dirty thing, but it's another dirty act that I'm telling you right now. If if Franklin Tucker decides to go forward, like he has told some people he's going to, and fire his attorney, it's another nail in his coffin. He needs an attorney. He needs an attorney to navigate things like this. He needs an attorney to help him. And again, I'm continuing to attempt to try to get in contact with him. He knows how I feel. He knows he knows I believe he needs an attorney. But I don't know that anybody's going to probably be able to convince him of this or move him off of this, because I think he's concerned that a lot of the support that he has, the image that he has publicly, is built around him being a pro se defendant who's going to go in and beat the system on his own. Look, the facts, the evidence are on his side. But the problem that he doesn't understand is that the threat of an appellate court coming in is what keeps a judge in line. The threat of an appellate court coming in and reversing a case is what keeps a prosecutor in line. It is not an indication of guilt because you protect your record. It's not an indication of guilt because you object and you raise an issue. That is how you keep things fair. When you don't do that, and they know you're not going to do that, and they know that from the first experience, these guys are going to be emboldened, absolutely corrupt. And that's why I believe Jones got out of this thing, because I think Jones, after sitting through that case, having witnessed exactly how bad it was, having seen the extent that these prosecutors were willing to go to convict this guy, he realized Tucker's an innocent guy, and he couldn't stomach it anymore. And he knew there were people watching. So what did he do? He stepped aside, and they took the new guy on the block, the guy who needs to make a name for himself, who needs to demonstrate his worth to the Key West legal community, James Jimmy Morgan. And in comes Mr. Morgan to come in and finish this deal and put this guy away. And he figured, you know what? It's a fresh face. It eliminates a lot of the problems that they had. And yet, with a close look, inspection of Jimmy Morgan, he's more corrupt than Judge Jones. And he's willing to go further to lock up Ty Tucker than Judge Jones was. And this is disturbing. And you have to ask yourself, Jimmy Morgan, if you happen to watch this or come across this, you've got to live with yourself, man. You've got to look in the mirror every morning. You've got to understand. You've got to do that. Now, Mansfield, Ward, those guys somehow are doing it, mainly because or him in their eyes. But that's not the case for you. You've been in this case from the beginning. You don't have to go carry this water. You can do the right thing. And we're going to get to about doing the right thing if you want to end this thing. All right. So give me a moment here. And here's what the looks like, guys. Here's what the right thing looks like. The right thing looks like this. and it involves granting this motion right here. And we're going to read it to you because this is the emergency motion to dismiss that they oh, you know what? Shoot. I picked up the wrong file. Give me a moment here. I want to see. I think I have it on. Hopefully I have it on my computer. If not, I can go in and grab it. From the Monroe County Clerk of Court's office. I think luckily I'm on the Monroe County Clerk of Court's office, so I can very easily grab it. No problems there. That was the show calls. For some reason, this, let me see if I have it in my recents here. I think I do, actually. Hold on. Yes, I do. Awesome. All right. We can make this real simple. I don't even need to go through what I was going to go through there. I can actually plug that right there. All right. Excellent. So give me a moment here. Let's go in and let's go to the full document now. I apologize, guys. All right. So here it is, guys. This is the, again, like I said, this is the, if James Jimmy Morgan wants to ensure good nights of rest for the rest of his life, he grants this motion here. And let's read it together here. Comes now pro se defendant Franklin Tyrone Tucker, hereinafter Tucker, files this emergency motion to dismiss with prejudice according to the local rules that govern emergencies due to significant errors made by the trial court, and an immediate hearing is necessary to prevent any further damage to the defendant. The defense in this motion and at such hearing is prepared to argue that beyond the egregious misconduct already presented to the trial court in the defense response to the state's motion in limine, the state currently doesn't even possess probable cause, much less a prima facie case necessary to take the defendant to trial. As such, the defense requests the court to hold an immediate hearing as is required for such a motion. And if the state is unable to produce facts to support its case against this defendant, then the court ordered this case be dismissed with prejudice so that he may never face wrongful prosecution for this crime ever again. As grounds for this motion, the defense would offer the following facts. Now, if you want to do Tyrone Tucker a favor, share this video, number one, and two, send this document en masse to Vinnie Politan, to Law and Crime, and get someone to cover this motion. Okay. And I'm going to try to do that. I've already sent it out. I don't know if anyone's going to see it, but this is what we want people to be reading. On April 30th, 2024, the court revoked the bond pretrial release and issued a warrant for the defendant's arrest. 2, even though the defense believes the court made significant legal errors in its actions, the defendant was arrested on May 3rd and has been incarcerated since that time. 3, again, the defense feels the court made significant legal errors and acted prejudicially in issuing a bond that the court knows the defendant can't afford at a ridiculous $3.1 million price tag. However, while it's clearly in violation of the 8th Amendment of the U.S. Constitution, the court did make good on its threat to keep the defendant locked up until trial. 4, the above situation has created serious peril for the defendant and necessitates the ending of this farce immediately before the defendant is forced into another faux trial where the state is given every advantage by the court, and the court, in fact, is in collusion with the state. 5, proof of this scenario can already be seen in the court's words and actions, as the court has blatantly ignored the law in many misdeeds of the state, choosing to instead punish a man who is supposed to be presumed innocent without any justifiable cause. Tyrone Tucker's speaking to us, people. He's speaking to us. You need to listen, and we need to get this out. 6, the court then chooses to further. However, the defendant's pleas fell on deaf ears. Wait a minute. There's missing documents. What the hell? That's weird. Oh, wow. Guys, I did not realize this. So I'm reading this for the first time, guys, with you guys. They have suppressed and redacted certain portions of this. Look at this. 6. The court then chooses to further. Where is 7? Where is 8? Where is 9? Where is it, guys? The court then chooses to further. Boom, nothing there. However, the defendant's pleas fell on deaf ears as the court coldly proclaimed, put it in writing. 10. Unfortunately, the defendant had not even been provided with a pen or paper at that time, but as a result of the court's denial for a hearing, every prediction the defense told the court came true. The defendant, as a result, lost his home, most of his belongings, his finances, and an unyet known portion of his business. He was also served divorce papers from his spouse the very next day on the 29th of May, 2024. So the defense would like to thank the court for paying so close attention to the ideas of fundamental fairness as we put this request in writing for your consideration. 11. As the following causes will show, this is just further damage due to a factually innocent man, while an emergency hearing would seem more than warranted to prevent any more damage to a man who has suffered almost 7 years of abuse. The defense is sure it will again fall on deaf ears, and the only justice that the defendant will get is by putting it in writing for the third DCA to review and writ of mandamus that will hopefully force this court to follow the law and end this nightmare for the defendant. Calls for a motion to dismiss with prejudice. 1. In addition to the court's own actions violating due process and the evidence already presented to the court of some of the state's previous and continued violations. Again, guys, I want you to understand, they're covering something up. And I'm going to reach out to some sources I have to see if we can get the rest of this, because this is crazy. I mean, this is crazy. They're actually covering up what, and those are things that happened in the hearings that we couldn't see. And they did not put the complete motion into the record. And I don't know if that's meant to have happened, but that's insanity. In addition to the court's own actions violating due process and the evidence already presented to the court of some of the state's previous and continued violations in the defense response to the state's motion in limine, the following will establish that the state can't even provide probable cause to take this case to trial, scheduled to begin September 5th, 2024. At the first trial, the state's entire case rested on the testimony of its one and only material witness, John Travis Johnson. Through significant error by the trial court, the defense was wrongfully, okay, wow, they redacted it again. So it's redacted again. We get to number 3. 14. Evidence of this lie was also given to the court in the defense response to the state's motion in limine, as well as being seen by millions of viewers on live TV and via the internet. 15. In any case, even barring the gross misconduct already shown to the court without the testimony of John Travis Johnson, the state has no prima facie case against the defendant, which demands dismissal by the court. However, with the many acts of egregious misconduct, the defense would argue it must be with prejudice. As a reminder to the court, the state violates due process when it requires a person to stand trial and defend himself against charges it knows are based on perjured material evidence. Anderson v. State. 17. A lawyer shall not knowingly offer evidence that lawyer knows to be false. 18. Deliberate deception of the court and jury by presentation of evidence known by the prosecutor to be false involves the corruption of the truth-seeking function of the trial process. State v. Agar. 19. Moreover, deliberate deception is inconsistent with any principle implicit in any concept of ordered liberty. 2. Governmental misconduct that violates the defendant's due process rights under the Florida Constitution requires dismissal of criminal charges. 21. The court has numerous cases to dismiss this case with prejudice and absolutely no reason it shouldn't. To continue to punish this defendant when the court knows the state has no prima facie case, the defendant was already placed in jeopardy once, and the state has broken almost every ethical rule, and its prosecution would be an absolute perversion of justice. Therefore, the defense requests this court to immediately dismiss the case with prejudice and stop this disgusting persecution of an innocent man. Wherefore, the defendant requests this motion be granted by the court. with any further relief the court deems necessary in the interest of justice. I hereby certify that a true copy of the foregoing was sent to the state via program services at the Monroe County Center. Respectfully, I'm flabbergasted, guys. They literally cut out the parts that we all know, the parts that discuss how John Travis Johnson's lying. And that's important because, again, if a prosecutor puts forth testimony that it knows to be false and suborns perjury, that is a violation of the due process rights of a defendant, and the remedy is immediate dismissal of the case. And again, it just makes what they're doing in this case in regards to John Travis Johnson's attempting to bar John Travis Johnson's motion to suppress, keeping Todd O'Quinn out. Guys, when I say this is one of the dirtiest, most corrupt cases I've ever seen, it's true. And you should be angered by this. And I've seen people in my comment section come in and they're claiming that he's guilty, and there's no basis for it. There's no basis for it. The state has no evidence, zero evidence. And of course, you've heard me passionately argue this, but that you're seeing in front of your eyes, apparently, again, this motion was not allowed to be shown immediately. And they have, I'm assuming, redacted the portions that they don't want. But there is nothing in those portions that shouldn't be made public record. I don't know what they are, but I already probably do know what they are. But it's stuff that somebody like Vinnie Politan, somebody like Law and Crime, they don't want this stuff out. But this is why what am I talking about? This is why Tyrone Tucker must have an attorney with him. He needs an attorney to ensure that he has any chance to beat these guys. These guys are the most corrupt, disgusting, terrible. It's scary. It's horrifying. It's the most vile thing I've ever seen. And we're seeing it live right here. And again, I had not read this yet because I hadn't had a chance to. I wanted to read it online or read it with you guys. Now, let's go to the, I guess, the Tucker response for just show calls. Let me see here. Is this okay? Here we go. So we're going to do this one here. And like I said, we've got one other one to do. But let's check this one. Let's see if they've redacted anything on this. Motion for order to show just cause comes now. Pro se defendant Franklin Tyrone Tucker moves this court to issue an immediate ruling in order to show cause, arguing against the state in support thereof. The defense would offer the following causes for granting such an order. 1, as was previously indicated in the defense motion to modify the no contact orders of state witnesses in this case, victim witness Todd O'Quinn has made clear his intention to testify for the defense at trial. Look, this is important information. This is something we want to share as well. 2, unknown to the defense, the state issued a subpoena that was served to this witness on March 25th, 2024, which required he be available to testify before this court at trial for the state. 3, the dates given to this witness to appear at trial were the weeks of May 13th to the 24th and June 3rd through the 14th. Now, what he's alleging here and what he's trying to show here is they were trying to confuse Todd O'Quinn to make him think that this is when the trial was. And then when the real trial came, he would think, oh, well, you know, what happened? You know, I never got a subpoena. He's confused about the dates. The state was aware the trial court scheduled the trial to begin in September of 2024. 5, on June 13, 2024, the defense received a copy of a state motion for an order to show cause against this victim witness for failing to appear at their faux trial dates. That's unbelievable. This victim witness has stated many times in video interviews that he fears reprisals by the state for testifying truthfully for the defense. So basically what they're saying is they filed a show cause, which would have allowed him to be taken into custody, which would have required him to show up for court for not showing up for dates that didn't even exist. What is going on here? I can tell you what's going on. They want to get Todd O'Quinn back in custody. They want him back in because they want to try to intimidate Todd O'Quinn to keep him from testifying and keep him from being available because they know he is the like if they can silence Todd O'Quinn, they will be very confident going into this trial that they're going to be able to run right over Ty Tucker and get a conviction. As I mentioned, and as I went over the way I believe they will do that earlier. The state is very aware that the testimony of this victim witness is more than damaging to their case against the defendant. 8. This eyewitness not only has stated many times that it wasn't the defendant he saw that night running away from the crime scene. 9. In addition to his statements that it was not Mr. Tucker he saw that night, he also pointed to a picture of the state only material witness John Travis Johnson when shown a photo lineup. 10. Making matters worse for the state, he also totally contradicts the state's theory and Mr. Johnson's testimony in his first statements made to the police by saying he saw the white suspect take off his mask while running down the street and then jump into a truck and take off. 11. The testimony of this witness victim negates the idea that John Travis Johnson was just the getaway driver, as the state claims, and instead makes Johnson the second assailant, as all the evidence has always supported. I'm so glad that's in there because that's the basis and crux. I'm glad he put that in there. That's what I found. That was the testimony that I found, and that I believe vindicates Ty Tucker because it shows John Travis Johnson was the second guy. It shows that he jumps in the truck. It corresponds with Paula hearing a vehicle start up, and to me, that is the exculpatory evidence that absolutely proves that John Travis Johnson isn't telling the truth and that he was more involved than what he told the jury. And the only witness, the only thing linking Ty Tucker to this case is John Travis Johnson. If he falls apart, their case falls apart. As Mark Kerman said in the OJ case, I'm everything. If I go, bye-bye state case. If John Travis Johnson goes, bye-bye state case. And that's why they don't want Todd O'Quinn on the witness stand. While the state has the right to subpoena witnesses to legitimate hearings or trial date, it does not have the right to abuse that. What does it say? To abuse that power simply to harass victims and witnesses for the defense. As the court is no doubt aware, the Florida Constitution contains a list of rights for victims of crime, commonly called Marsy's Law. One of these rights is to be free from intimidation, harassment, and abuse. 14, the defense will submit that this law applies equally to the state as it would be to the accused. 15, this is not the first time the state has abused a victim in this case because they wanted to testify for the defense, or the first time the defense has had to cite Marsy's Law in order to protect the rights of the victims in this case. 16, at the first trial, the state in court tried to prevent a victim, Ms. Paula Belmont, from testifying for the defense. She was gravely ill and in the hospital, and once again, the defense had to argue Marsy's Law, which allowed her to testify via Zoom. However, when her condition got worse and the defense made an emergency request to let her go out of town, both the judge and state mocked her illness, accused her of faking it, and ended with the judge making a disgusting ruling that even if the defense produced a doctor's note, saying she was dying, he would not let her go out of turn. So after being mocked and called a liar by the judge and state, Ms. Paula Belmont passed away on February 6, 2024, less than 2 weeks after the trial. 17, in his public statement, announcing his intention to retry the defendant, the state attorney Dennis Ward made the horrendous remarks that he was doing it for justice for the victims. He even named Ms. Belmont in his loathsome rhetoric. In reality, the only person who has fault for the victims in this case is the defendant, whose tolerance for the state and courts rancid behavior, especially towards the victim, is most definitely at an end. If the court and state wanted to forego this fake trial, throw a rope over a branch and have this be done, then fine. However, stop treating the victims in this case as if they're the criminals just because they won't help you. Tie the knot. 18, the defense is fully aware that the defendant is not a licensed attorney, and he is only allowed to make arguments in this case. That would include any motion filed in this case, including the state's motion to show cause. Equally, the defense has the right to protect its witnesses and a duty to remind the court to protect the victims in this case. As such, the defendant is not acting as an attorney, but an innocent man who has been forced to defend himself, and a moral man asking the court to defend those that he cannot. Wherefore, the defense requests the court to deny the state's motion and instead issue an order for the state to show cause for its blatant harassment of a victim and witness for the defense. If they cannot provide just cause, then the defense requests that they be barred from issuing any more fake subpoenas and a no contact order be issued against the state to protect this victim from further harassment. I hereby certify that a true copy of the foregoing was sent to the state attorneys at the Monroe County Detention Center via program services at the Monroe County Detention Center on June 26th. So you can see this motion came from June 26th, but it's an important motion for what it contains. So again, this needs Ty Tucker is communicating with us through these motions. They're not letting it all get out to us. The fact that they redacted or forgot to scan in or whatever their excuse is on that motion to dismiss is absolutely disgusting. But that should tell you everything you need to know about what's going on here. Now, let's switch to the final document that we have to look at today. Again, this is going on a little bit longer than what I was expecting, but that's okay because it's very important that we get through these things because I want to show you these. I believe this is the one right here. Yep. All right, share. So this one they scan in backwards. Oh, wait a minute here. Hold on. Okay, so it looks like this was I don't know what this was an attempt, I think, to redact further, maybe that wasn't successful. I don't know. That's very odd because they had updated, they had downloaded two of these. This one looks like it was an attempt to redact some of what was in there, but an unredacted version of that motion got in. So I guess we don't have another motion to go over. So that's fine. That bizarre stuff. Listen, guys, what's going on with this case file is absolutely ridiculous. You just saw, again, I just showed you, and Tucker told me that this is what was going to happen. They're withholding stuff. They're trying to cover up stuff. They're keeping out portions of his motions, legally filed motions. There's no good reason why they should be redacted. There's no good reasons why they should be censored. There's nothing in there besides the fact that there's embarrassing questions that they need to answer, and they don't want to have to answer it. Mansfield doesn't want to have to answer for his behavior. Ward doesn't want to have to answer for his behavior. They should. They absolutely should. And they should be required to, because what's going on in this case is absolutely a travesty. It's a travesty of justice. But it's unbelievable. So, look, I understand. I can tell by these motions potentially that Tucker probably feels like if he gets an attorney involved, he's going to get shut down. He's not going to be able to speak through these motions like he's doing right here. He's not going to be able to state his case. He's not going to be able to verbally attack the court and the judge. But what he's got to understand is that an attorney is going to be able to hopefully equalize the situation here and limit the damage this corrupt judge, corrupt prosecutors can do to him. I got to believe that a public defender down there who's looking at this case is going to look at this case and say, no way we can let this stand. I'm going to fight this case. I'm going to fight for Franklin Tucker. I hope that's what I'm hoping, at least. But I don't know. Maybe not. Maybe I'm being a little bit pragmatic. Maybe I'm expecting a little bit too much out of anybody in Key West. But look, this judge, like I said, the motion to dismiss is missing the most important pieces. the most important pieces of his case, what he wants to get out, which is basically talking about what they did with Travis Johnson and how they uh, suborned perjury in that instance. I mean, that's crazy. And then you have here one motion is the full motion, which actually got through. I don't think they realized it. And the second motion is another attempt at a redaction to cut out all the stuff that they don't want, the embarrassing revelations that he's bringing. Now, I don't suggest in any way, shape, or form that these motions will be granted. I don't think they will. Jimmy Morgan's going to turn them down. And I do believe Jimmy Morgan and his cohorts and his band of jolly criminals are attempting to get him to waive his right to counsel. That's what he's done. Just like they got him to waive his right to a speedy trial. And they're going to walk him right down the plank. And it will only be up to a juror who sits on that jury box, who sits in that jury box, who hopefully hears this case, who listens to Franklin Tucker if he does in fact handle his own case. And maybe, I hope, says something's wrong here. This doesn't feel right. This isn't right. And that they intervene. But we're not going to stop fighting out here. We're going to keep bringing attention to this. But what I need from you guys, what I need from any of you 30,000 people out there that are subscribed to this channel, I need you to share this video. But more importantly, I need you to go and get the word out. I need you to send these motions to Vinnie Politan at Court TV, to Law and Crime. Hopefully they dig into the case file in preparation for the trial and they'll be ready to raise these issues. But we need attention. We need attention to this case. Call the public defender's office down there. Go on to the Monroe County Clerk's office. I'm not putting the numbers up. I'm just telling you it's part of the record. Call down there. Make your voice known that you are supporting Franklin Tucker, that you're supporting his movement, that you want to see justice for him. Let him know that he's got an army behind him and a coalition of people that are not going to stop fighting, that are going to continue to fight for him and make sure he's never forgotten, even if this thing goes south in September, which I hope it doesn't. But we got to fight, because this is a situation where the most dirtiest, corrupt people that could exist in a criminal justice system are going after an innocent man. And this is worse. Like, these people are worse than the killers that they're putting away, the criminals that they're putting away. They're basically the same. They're no better than them. And this is a sad, sad, sad situation. So I hope that we can make a difference here. And like I said, stand by, because we are going to be putting forth some of the most explosive testimony that you're going to hear in this case that you've never heard. And I hope Franklin Tucker is successful in subpoenaing Matt Pitcher. And you're going to see why when we go through his deposition, because it is explosive. It contains, and it leaves you with no doubt as to Franklin Tucker's innocence when you get done listening to this. And some of you may have read it, but you're going to get to listen to it for the first time ever, because I've been able to utilize AI software to be able to produce basically something you can listen to. And it hits different when you listen to it, because I've read it and I listened to it, and I'm going to listen to it again with you guys when we go through it. And we're going to talk about it in probably maybe a 4 or 5 hour segment. Might be longer, because sometimes I get passionate and want to talk. But we're going to listen to it. We're going to talk about it. And we're going to try to go get some justice for Franklin Tucker. Anyways, guys, hit that like button. That's another way you can help things out. Hit the like button. Hit the share button. Watch this video. Keep the lights on by watching the video. That helps us keep fighting. And get subscribed as well, so that you can stay up to date with the Ty Tucker case. Because between now and his trial, that is a majority of what we're going to be talking about. You noticed I haven't done any new trials. I've been putting all my focus on this case. We may pick up a case or two along the way if something comes up. But right now, I want all the focus to be on Tyrone Tucker. And we're going to be watching this case, talking talking about this case, and we're going to be trying to do our best to bring as much attention to this case as we can in the coming weeks as we ride on into trial time. Anyways, with that said, guys, let justice prevail. I hope it prevails in this case. Do your part. Hit the subscribe button. Hit the like button. Share this video. Get word out on this case. I'm putting up shorts right now. I put up a new short today. Watch the shorts and, share them as well, because there's valuable information for people to see and hopefully bring attention and awareness to this very important case. Anyways, guys, I'll talk to you soon. Pay attention for an alert for when we're going to be unveiling the picture testimony. I've got a couple of episodes coming up as well that'll be interesting, where we're going to watch some other, we are going to watch some other, court hearings and things that are going on. But like I said, a majority of what I want to focus on, I want to keep the focus on the Franklin Tyrone Tucker case. So until then, guys, let justice prevail, and I'll talk to you soon.
I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign. I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign.
I wanna be the greatest. Everybody on the fake shit. I look around and feel like everybody is the fakest. I make this every day and I'm impatient, hoping one day I blow up from the basement. Statement, the top is so vacant. I don't hear shit that I think is amazing. Waiting for my day when I'm playing sold out shows for 1,000 faces. Hey, give me that crown, get in my way and to be put down. It ain't your place, all this my town. If I want that shit, then I'll get it right now. I'm losing it, the noose it fits. I'm losing shit, a stupid myth. You choose to live or choose to dip. You choose to fight or lose your grip and lose a gift.
I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign. I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign.
Yeah. There's no mercy in this world, just hunger-thirsty persons in different versions, each new update, that shit worsens. Why? Pull back the curtain and you'll see the different vermin. We all have different burdens that all seem to cause disturbance. Yo, so do me a favor, don't treat me like a neighbor. Don't need the different flavors of your problems just to savor. I've got my own issues, I need a comb to get through. Don't need to groan with you, just go get your own tissue.
I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign. I feel like I'm losing my mind. Is everybody in the world blind? Please, Lord, give me a sign, a sign.
That's it, the end of the song. Next time you'll sing along. Trust me, there's nothing wrong. I just need to carry on, cause society's a myth put there to make you sit. Listen to what they give. Don't ask questions, shut your lid. Yeah, don't ask questions, shut your lid. I need to run away from this and go get off